Hello everyone and welcome to Prosecutor in the Saddle. I'm Lawyer Lee and today we're going to talk about a historical rape case that I think it's really important to discuss even though it's not a current case. So just bear with me for one moment. Sorry about that, I completely forgot to put my glasses on. So I've seen a lot of criticism recently and over the years of judges, the judicial system, and every profession really that falls within the criminal justice system. Some of it I agree with, other bits I really don't. But every now and again, there is a case that demonstrates two extremes of the criminal justice system. So in this particular case, we've got on the one hand, someone who was wrongly convicted and spent 17 years behind bars for an offence that he didn't commit, a serious offence. And on the other hand, we've got more recently the judge sentencing the actual offender. And he got things so right that I want to shine a light on him. Mr. Justice Bright's sentencing remarks in this particular case were so profound. They were just so right that they will no doubt have a long-lasting impact on the victim, who's had to endure, remember, not just the offence and the aftermath of that, but 2 trials and the lifelong effects of this type of crime. And I suspect that Mr. Justice Bright's remarks will have made her feel honoured, I suppose is the right word, honoured in a way that most judges never will make a victim feel. When I see questionable conduct or systems that are going wrong, I'm going to call that out. But we do that as a society anyway. What we don't do is shine a light on the good conduct, or in the case that we're looking at here, great conduct. We talk about all the things that are wrong with systems and never what is right. In this case, I've got very little following at the moment, I understand that. But the internet's forever. And this case might just inspire some members of the criminal justice system at some point to take a leaf out of this judge's book in their professional life. And I hope that I can take a leaf out of his book, because I have to deal with communication with victims as well on a daily basis. For those of you who haven't been here before, I'm a prosecutor in the UK. So I'm a senior Crown prosecutor, which means that I deal with Crown Court cases, and that's the more serious end of offending. When I'm not in work and I'm not dealing with cases, I'm either on here because I clearly can't get enough of true crime, even though I work in the industry. And more importantly, I will either be with my family and 2 dogs or out on my horse, hence the in the saddle. And if I'm not in that saddle, I'm going to work on my motorbike. So I'm in a different kind of saddle. But Honey's saddle is the one that I like to spend the most time. But I don't come at this from just a YouTuber perspective. I'm coming at this from I can take a leaf out of this guy's book. So what's the case about here, you ask? Well, it's the case of Paul Quinn, and previously the person who was wrongly convicted was Andrew Malkinson. Now, we don't know, and nor should we know, the identity of the victim. She's been granted lifelong anonymity by the judges in this case on both occasions. I'm going to read out the full sentencing remarks from the judge because they are truly profound, and I don't want to do them an injustice by paraphrasing them. And I'm hoping that they're going to give you the same warm, fuzzy feeling that it gave me in my heart when I read them. Watched it, actually. So you can actually find, and I'll link it in the description, the original remarks by the judge. The case involves a sex attacker who violently beat and raped a woman in 2003 in an attack that led to the wrongful conviction of Andrew Malkinson, and he spent 17 years in prison. Paul Quinn, excuse me, now 52, evaded justice for more than 2 decades, but was found guilty of 2 counts of rape, 1 count of choking with intent, which now would be strangulation, and 1 count of grievous bodily harm, after new DNA evidence linked him to the crime. So at the time in 2003, Paul Quinn's DNA wasn't in the system. He since has been convicted of other offences. His DNA was taken, put into the database, and then there has been a reconsideration of the case, basically because Andrew Malkinson, as an innocent person, did not stop seeking justice. So, bear with me. The victim, who was then a mother of 2, was walking along Cleggs Lane in Little Hulton near Salford. Now, that's not too much further than a stone's throw from where I live, in the early hours of the 19th of July 2003. She was followed, some might even say hunted, actually, and pushed down an embankment before being beaten, raped and strangled by Quinn. And in fact, it wasn't in that order, but we'll get more into that within the sentencing remarks. There was an e-fit and a description of an attacker produced by the police. And back then, Andrew Malkinson was picked out of a digital identity parade by the victim and 2 other witnesses. So he does bear some resemblance to the e-fit and the description. He was released aged 60 in 2020, and his conviction was finally quashed by the Court of Appeal, and he was exonerated in 2023, so that's quite recently. Quinn, who had always denied any involvement in the attack, was linked to the crime in 2022 when the DNA evidence emerged, and he was convicted after a 6-week trial at Manchester Crown Court. And during sentencing, Mr. Justice Bright described Quinn's victim as a hero, paying credit to her quiet dignity at having to give evidence in 2 different trials. And he sentenced him to a term of 21 years in jail with an extra 3 years on licence after release. So let me take you through the sentencing remarks word for word. Once we've done that, I'll talk you through a little guide, a timeline that we found on the BBC's website, which is quite illuminating in terms of how the case progressed throughout the years. But now we'll go through the sentencing remarks. Paul Quinn, you were born on the 8th of April 1974, so you are 52 years of age. You were found guilty by the jury on 4 counts for which I now sentence you. Count 1 was attempting to choke, suffocate or strangle contrary to section 21 of the Offences Against the Person Act of 1861. Count 2 was causing grievous bodily harm with intent contrary to section 18 of the Offences Against the Person Act 1861. Count 3 was vaginal rape contrary to section 11 of the Sexual Offences Act of 1956. And count 4 was anal rape contrary to section 11(1) of the Sexual Offences Act of 1956. Now, let me just pause the remarks here to say that had this been a more recent crime, there is a current offence of strangulation and suffocation. And there is also a new Sexual Offences Act that came out in 2003, but wasn't in effect at the time of this particular offence. Now back to the remarks. And for all 4 of these counts, the maximum sentence for the offence is life imprisonment. It has long troubled me that our judicial system has utterly inadequate terms for the person to whom the crime is done. We use the word complainant, but this sounds like someone griping about a trivial grievance. We use the word victim, but this sounds like someone with no agency, who merely passively endures whatever is inflicted on them and lacks the gumption to do anything about it. Using these terms is demeaning. No crime ever feels trivial to the person affected by it. The crimes dealt with in this court are all very far from trivial. Cases like this one are as serious as it gets. Moreover, anyone who supports a prosecution that is brought to trial is far from passive. It is a lengthy and demanding process that requires courage, persistence, and willpower. Far from lacking agency, such people have gumption by the truckload. Rape cases are perhaps the most clear examples of this. The people, usually women, but not always, which suffer rape, which then results in a trial, go through a very great deal to help our judicial system. Every single one of them should be thanked and admired unstintingly by every single one of us. Much has been said in the past several years about how uncomfortable our processes are for people who have endured a rape, having to tell their story over and over again to the police, to the CPS, and ultimately to the jury. I'm well aware that, in fact, there are nowadays scores of carefully trained and sensitive professionals in the police, in the CPS, in witness support, and in several other bodies who go to great lengths to care for and help the people affected. I wish that excellent work they do were better publicised. Nevertheless, it is an undeniably uncomfortable process. The people who put themselves through it are, in my view, heroic. For me, the only word for them is not complainant or victim, nor even, as is sometimes now termed them, survivor. The only word that fits is hero. That is how I choose to think of a woman at the heart of this case. She not you, Paul Quinn, is the person from this case whom I will remember for the rest of my days. She is truly a hero. That is the term I use to refer to her from this point forward. In part because I do not wish to use her name, but mainly because she deserves it. Our hero gave evidence at the first trial in 2004. That will have been hard enough. And she must have thought at that time that particular ordeal, at least, was over and done with. But a few years ago, the police had to break the news to her that it seemed that the wrong man had been convicted. So she might have to go through the whole process again. She came here and she did exactly that. It was obvious to everyone here how excruciating she found it to come back to court a second time, and how much it took out of her. Remarkably, she gave her evidence in plain sight of you, Paul Quinn, without asking for the protection of a screen. She gave her evidence clearly, in an entirely straightforward and direct manner, with no histrionics and no obvious rancour. But every step through the courtroom to the witness box looked agonising, and she clearly suffered horribly as she retold what happened, which she did with quiet dignity, but through a constant stream of tears. No one who watched that can have been left unmoved. She is a remarkable person. And I say all of this to give public tribute to her and to others like her. They do not come here for vengeance, which we do not give them. They do not come expecting closure, which is largely a mythical phenomenon, especially after an event such as rape. They come here because they want the truth to be heard, and because they know it is the right thing to do. Without them, it would not be possible to bring the guilty ones to justice. And this is why she, far above any of the police or the lawyers or the DNA scientists, is the hero of this story. I now come to the critical events. In July 2003, our hero was about 30 years old. It was a Friday. She finished work early that afternoon and went to her boyfriend's house. There was a small social gathering which went on for some hours. After it ended, she decided to walk back to her own house. This was quite a long journey. Longer, I suspect, than she realised when she started walking. The route required her to walk along Peel Lane, then along Armitage Avenue, and then along Keel Lane to the bridge that passes over the M62. By the time she got to this part of the journey, she had been walking for quite a long time. It was now after 4 a.m. It must have been around this point, Paul Quinn, that you first saw her. You were walking in the opposite direction. You had been out drinking, dancing, and taking drugs in Farnworth. First in some of the pubs there, then in a club. You'd gone there with a friend, but it seems that he left before you did, as he sometimes would, and you were walking home by yourself. You walked across a bridge over the M62, down Clees Lane, and then down Armitage Avenue towards your home in Little Hulton. By this point, you were not very far from home, but you interrupted your journey because you saw this young woman out late at night walking by herself. She first became aware of you as she passed an area on Armitage Avenue with some bushes opposite the Woodlands Hospital. She did not see you at this point, but she heard someone with a voice which she described in terms similar to the way she described your voice calling her from the bushes, threatening her and telling her to come and join you in the bushes. This must have been you. And this means you must have seen her coming, got in the bushes, and concealed yourself before she walked past. She walked on. You then turned around and followed her, now walking away from your own home. We know this because the two witnesses who passed twice along the road saw her and a man following her who must have been her attacker. In other words, you were walking behind her. The first time they saw you both, you were about 30 seconds behind her. The second time, you were much closer. By this point, she was aware that someone was following her, and she was beginning to be anxious. She carried on walking. As she neared the bridge, you pounced. By this time, you had been following her for at least 0.9 miles, which, when the policeman later walked the same route, took him just over 16 minutes. You must have been watching her for slightly longer, from at least just before the moment you first hid in the bushes, waiting for her to get there. You waited until the perfect moment when no one else was about, and you waited until she arrived at the perfect point in the road, which you knew very well, as this is where you had lived nearly all of your life. You raced at her from behind and bundled her off the road, over or through some wooden railings and down a steep embankment to a level grassy area, which was sufficiently far from the road and sufficiently below it to be completely out of sight. You dragged her through the undergrowth, wrestling with her to get to this particular spot. You again threatened her and took her phone off her when she tried to use it to get help. You put your hands on her neck and strangled her. She thought she was going to die. She passed out. This is the Section 21 offence in count 1. While she was unconscious, you hit her, possibly with your hand, but your hand does not appear to have been injured, though possibly with an object. You hit her face so hard that you broke her cheekbone. It was badly shattered, such that she later needed surgery. Her face is still somewhat disfigured. She sees the injury every time she looks in the mirror and is reminded of what happened. You removed or disarranged her clothing. At some point, you had access to her breasts. You bit her left breast so severely that the nipple was partially severed and hanging loose. This caused profuse bleeding. The injuries to her face and to her left breast give rise to the Section 18 offence. I say again, this was committed while she was fully unconscious because you had strangled her into unconsciousness. And then again, whilst she was still fully unconscious, you raped her. Not once, but twice, in the vagina and in the anus. Before she lost consciousness, she remembered you ripping her knickers. When she regained consciousness, they were completely torn and were hanging off one ankle. You had left, and she could not find her phone. You appear to have taken it away, presumably to stop her using it. It is not clear how long she was fully unconscious. We know that she sent a text message from her phone at 4:26 from a location so close to the site of the attack that it can only have been a very few minutes before the attack occurred. We know that she regained consciousness sometime before 5:30 that morning, which was approximately when, having managed, after several efforts, to get back to the top of the embankment and onto the road, she encountered an early morning dog walker who came to her assistance. It is therefore conceivable that she was fully unconscious for up to an hour, although perhaps about 30 minutes is a more likely upper limit, bearing in mind her evidence that she drifted in and out of full consciousness for a while, and it took her some time to get to the top of the embankment. She was certainly fully unconscious long enough for you to commit all of the offending in counts 2, 3, and 4, and then get clear of the scene. So it is hard to see that the period of unconsciousness can have been much less than about 10 minutes. After she met the kind dog walker, he took her to his house nearby. The police were called from there at 05:40 and arrived at 05:55. It was on this occasion that our hero gave her first account to the police. Her evidence has been essentially consistent ever since, and in the main was not really challenged in the course of this trial. As is well known, the attention of the police swiftly focused on Mr. Andrew Malkinson, who was the subject of the original prosecution and trial in relation to these matters. Following his conviction in 2004, he remained in prison until December 2020. Mr. Malkinson's attempts to have his conviction Sorry about that interruption. Mr. Malkinson's attempts to have his conviction overturned did not gain much publicity until his release. The journalist who principally championed his cause, Miss Emily Duggan, published her first article on this subject on the 13th of September 2020 in the Times. This was followed by a series of podcasts and increasing media coverage through 2021 and 2022, until Mr. Malkinson's successful appeal into 2023. The prosecution were not able to find evidence covering your activities over much of the period from 2003 to 2020. However, it is notable that cloud records of your phone activity reveals that on the 12th of September 2019, you visited an old story filed on the Manchester Evening News website back in 2004 concerning Mr. Malkinson's conviction. You were interested in that story when very few other people were. On the same date, you also searched for Wrongly Convicted Cases UK, although very few people then thought that Mr. Malkinson had been wrongly convicted. The prosecution case against you was primarily based on DNA evidence, which it is not necessary to summarise for the purpose of considering your sentence. However, the prosecution also relied on the internet searches I have just mentioned, as well as other evidence relating to your search history. They said that it demonstrated that you were aware all along that Mr. Malkinson had been convicted of the offences committed by you in July 2003, and that you were also aware all along that he had wrongly been convicted because those offences were in fact committed by you. I have no doubt that the prosecution were right. This means that you knew not only what you had done to the woman who you so savagely attacked and raped, but you also knew of the knock-on effect on Mr. Malkinson. Neither of these things appears to have troubled you at any point during the 20-plus years that have since passed. Not even during the trial, nor when you were interviewed by the probation for your pre-sentence report. I now come to your previous convictions. You've been convicted of 6 previous offences on 4 occasions, all when you were young. In 1991, you were convicted of 2 offences involving sex with a 13-year-old girl. You committed the offences when you were 15 or 16. You were sentenced to 180 hours of community service in 1993. You were convicted of arson endangering life in 1993 when you set alight to a plastic wheelie bin, then placed it against the back door of your ex-girlfriend's. In 1993, you were sentenced to try that again. In 1993, you were convicted of arson endangering life. You set light to a plastic wheelie bin, then placed it against the back door of your ex-girlfriend's property, while she and her children were in bed. Excuse me. The back door of the house burnt through the kitchen, but fortunately, the fire spread no further and no one was injured. You were sentenced to 2 years in a young offenders institute. I can see that in 1992 you were convicted of 2 offences of ABH, that's actual bodily harm. However, I know nothing of the circumstances save that you were sentenced to a 12-month probation order under 100 hours of community service. You incurred no convictions between 1993 and the commission of these offences in July 2003, and none since July 2003 either. I turn now to the offending under counts 1 and 2. Both Mr. Price Casey for the prosecution and Miss Wilding Casey never just read directly from the transcript without having properly gone through it word for word. Both Mr. Price Casey for the prosecution and Miss Wilding Casey for you agreed that the best approach in principle was to treat one of the rape offences, or perhaps both, as the lead offences, these being the most serious, and to pass concurrent sentences on counts 1 and 2 with adjustments for totality. This is undoubtedly the best and most convenient course, which I am happy to adopt. Furthermore, it is also undoubtedly correct that the 2 rape offences are the most serious. However, it would not be right for the other offences to be glossed over too quickly, as if they were mere also peripheral items. Considered in their own right, each of them is extremely serious. I deal first with count 1, the Section 21 offence. As regards this, whilst it is not clear precisely how long the period of unconsciousness was which resulted from the strangulation that you inflicted, it must have been several minutes. Furthermore, it was an unconsciousness so profound that the heroic woman you put through this remained fully unconscious despite the extreme nature of what happened to her in the course of counts 2, 3, and 4. The pain involved in the injuries to her face and her breast, and in the forced penetration of her vagina and anus must have been extreme. That she nevertheless remained unconscious throughout all of this and until some time after you had left makes this a very unusual and serious case within the context of Section 21. It resulted in all the classic indications of manual strangulation, bruising to the neck, and particular bruising in and around the eyes and in other typical locations. However, the reality is that the woman who I say is a hero is very lucky she did not die, and luckier still that she did not incur significant brain damage, given the oxygen deprivation that must have occurred in order for such a long-lasting and profound unconsciousness to have resulted. You were not charged with attempted murder, and I have no doubt that you had no intention to kill. However, you were unquestionably reckless in the sense of paying no heed whatsoever to the very obvious risk that what you did might cause death or very serious and long-lasting injury. There is no sentencing guideline applicable to the Section 21 offence. However, I was helpfully taken to a number of relevant authorities, including the Crown against Enston in 2002, EWCA Crim 1375, where the victim was not quite rendered unconscious and a sentence of 6 years was upheld, as well as the judgment of the Court of Appeal of Northern Ireland in Crown against Stewart 2020, NICA 62, which emphasised the extremely dangerous nature of such offending. In addition, I've considered Crown against Woodbridge in 2018, EWCA Crim 1537, where the sentence after trial would have been 15 years. But that case involved considerably more planning, and the Section 21 offence was the lead offence and was sentenced as such. So the sentence on that count was increased for totality. I consider this is a serious case of the Section 21 offence class, and the strangulation that was affected was extreme, as was the unconsciousness that it caused. Taken in isolation, that is, if you had committed it intending to rape but then had not gone on to do so or commit any other offence, and considering matters without regard to aggravating features such as your extreme intoxication at the relevant time, my sentence would have been 12 years. I turn now to count 2, the Section 18 offence. As regards the Section 18 offence under count 2, I again find it helpful to consider this if approached in isolation. That is, on the basis that injuries to the face and left breast were committed with intent, but as if you had not committed the other offences. The fact remains that these injuries were intentionally inflicted on a woman who lay on the ground and unconscious and completely defenceless. They were serious injuries by the standard of that offence, albeit not the most serious, which have resulted in permanent scarring as described in the victim personal statement read to this court this morning. They were inflicted on someone who was utterly vulnerable. The offence falls into category A2, in my view, for the purpose of the sentencing guideline, with a starting point of 7 years and a range of 6 to 10. It allows that, if considered in isolation and without regard to aggravating features, my sentence would have been 7 years. I now turn to the 2 rape counts. It is convenient to deal with the 2 rape offences together, that is, counts 3 and 4, albeit I will ultimately have to reflect the fact that this case involves 2 offences, not merely a single one. They were necessarily charged as offences under the 1956 Act, not the 2003 Act that is now in force. But the current sentencing guidelines is nevertheless informative and relevant. As regards harm, this incident was unquestionably resulted in severe psychological harm. The injury to the left breast constituted additional degradation and humiliation. You wanted to leave your mark on her, which you did by inflicting a severe injury to one of the most intimate parts of her body. There was an element of abduction in that you deliberately bundled her off the road and down the embankment to a location where you would not have been seen or disturbed. It is unclear how long the rapes lasted. For that reason, I do not treat this as a prolonged incident, albeit it must have lasted for more than mere moments. It was certainly unusually violent, even by the standards of stranger rapes. As regards culpability, the prosecution have suggested that there was significant planning. I do not quite accept this in direct terms, as it seems unlikely that the idea of committing rape occurred to you much before the incident in the bushes. However, turning away from home and pursuing somebody for almost a mile indicates a commitment to the idea once it formed, and persistence. It seems that from the moment you knew exactly where you should make your move. In considering culpability, I find it impossible to ignore the significance of the Section 21 offence. Raping someone who has first been strangled into unconsciousness in the extreme way that you did, with the specific intention of then committing rape, is a very distinct manifestation of culpability, even if not one that is canonically recognised in the sentencing guideline. In saying this, I of course recognise that it is important not to double count by adding to the rape counts to reflect totality when I have already had regard to the other counts 1 and 2 when assessing harm and culpability. Ultimately, both counsel accepted that 2 rape offences should be treated as falling into category A1, with a starting point of 15 years and a range of 13 to 19 years. I consider that the gravity of the harm caused and of your culpability are a long way above the norm for an offence of this kind. I therefore consider a sentence significantly above the starting point, even before considering the effect of the aggravating features and totality, there being 2 counts of rape, as well as counts 1 and 2. I now turn to consider harm to Mr. Malkinson. One unusual feature of this case is that while the person most directly affected by the offences was the woman you attacked so viciously and raped, there have also been direct effects on Mr. Malkinson. The prosecution say that I should increase the sentence to reflect the harm done to him. The defence say that that would be unfair. His wrongful conviction is not attributable to anything you did or said, but to the mistakes made by the police and or the CPS and or the scientists previously involved. It is not for me to venture any opinion as to what mistakes were made or were not made in relation to Mr. Malkinson. However, I find myself unable to ignore the extraordinary circumstances involved from your perspective. As I have explained, it is utterly clear that you knew throughout that another man had been arrested, charged, convicted, and imprisoned. You knew that his conviction was wrongful. You also knew that it was extremely useful to you. It must have preyed on your conscience that another man was in prison, in effect serving your sentence. It certainly should have preyed on your conscience, but you were only too willing to sit back and take advantage of his misfortune. It is true that you never did anything positive to implicate Mr. Malkinson. However, but for your offending, he would never have been questioned. But for the care with which you made sure there was no evidence connecting you to the scene and that the shirt was disposed of, he would never have been suspected because the police would readily have identified the true culprit. But for your decision to allow his trial to unfold and his conviction to stand, he would not have remained in prison for the period that he did. It would be entirely wrong to compare the indirect evil that you have done to Mr. Malkinson with the direct physical evil that you have done to the heroic woman who suffered at your hands that night. But I do consider your conduct to both of them evil, and the harm done to both of them must be reflected in your sentence. I now turn to other factors increasing seriousness. The previous convictions for sexual offences are somewhat concerning, but not really comparable. The arson conviction is much more concerning because it indicates a complete disregard for the risk caused to others. So there is a resonance with the Section 21 offence for which I now sentence you. However, I recognise that the arson offence occurred a long time ago, a long time before these offences, when you were, I think, 18 or 19. Of more immediate significance are the following factors. First, our hero's vulnerability. She was a lone woman. Second, timing. This happened in the dead of night. Third, location. The precise place of the initial attack and of the spot where you then committed the offences was a matter of careful selection. Fourth, You took the mobile phone in order to prevent her from calling the police or otherwise getting help. Fifth, in fact, when you left her, she was still unconscious and obviously seriously injured in an isolated spot when no one would come to assist her. You effectively left her for dead. If she had not come to, and then managed to make it to the top of the embankment, which she found difficult, she would have died. Sixth, you disposed of evidence. Your shirt went missing after this night, presumably because it was blood-stained. The evidence on this point from your ex-wife was very compelling, and I am certain that it counted heavily with the jury. Seventh, intoxication. In your police interview, you accepted that you had been drinking heavily and probably also taking cannabis and or speed and or ecstasy. When you went out on these clubbing evenings, you did so with the express intention of getting drunk and high and then having sex. You were described by one witness as obviously, quote, off his head, close quotes. As already indicated, I will have to increase the sentences on the 2 rape counts to reflect the fact that there were 2 offences, and to reflect totality in general, subject to all the points already made about not double counting insofar as they have been taken into account. I now come to personal mitigation. You have been diagnosed with pulmonary sarcoidosis, which will require treatment and monitoring whilst you are in prison. However, this is not a reason for not imposing a custodial sentence. I have read the important and useful letter from your current partner, Lisa Palmer, who speaks very well of you, at least over the period she has known you. I have also read the similar letters from your niece and from your father. It is always good for the court to be reminded that any sentence that is passed does not only affect the person in the dock, it also affects everyone in their immediate family circle. However, this cannot and does not deter me from imposing significant custodial terms for all of these offences. This is simply the unavoidable consequence of criminal conduct of this kind. The fact that this will have dreadful consequences for others, perhaps especially Miss Palmer, is nobody's fault but yours. Now, I come to your apparent good conduct since 2003, or at the very least since 2017. Your counsel, Miss Wilding Casey, has very correctly emphasised to me that you have had no convictions since 2003. You have acknowledged that you had involvement in the production of cannabis. You received a caution in 2013, and in your interview by probation, you accepted involvement in a cannabis grow in 2016. However, the real force of all this is that your life changed significantly after about 2017. Until that point, your lifestyle continued unaltered, going out at weekends looking to get intoxicated and have sex. Indeed, in some respects, it worsened because you developed a serious cocaine habit. However, in 2017, you appear to have belatedly grown up. You moved away from Manchester, essentially left your old habits behind and formed a new relationship, which appears to be stable and healthier. Miss Wilding Casey has drawn my attention to the Sentencing Council guidelines on historic sexual matters, which states that an absence of further offending over a long period of time, especially combined with evidence of good character, may be treated by the court as a mitigating factor. She also directed me to the Crown against H.J. 2012 1 Weekly Law Reports 1416 at paragraph 47, which is to similar effect. I acknowledge that such matters require careful attention in this context. The Sentencing Council guideline also notes that the more serious the offence, the less weight that should be given to this factor. Furthermore, I fully accept that it is often for the court to know how the defendant, difficult for the court to know how the defendant has behaved since the date of the offence, because this may well provide good evidence of the defendant's character. If the offending behaviour was anomalous or a blip, that is useful information and very often leads to a different approach when sentencing. Furthermore, defendants sometimes can be seen to have taken charge of themselves in response to the offence and/or the resulting investigation, which often shocks them into making spontaneous efforts to alter the way they live and behave. This too is important when sentencing. The facts here are quite different. You may not have committed any further rape since 2003, but your behaviour continued to be very poor for a very long time. Indeed, in some respects, your beginning cocaine habit made it worse. I see no sign whatsoever that you have ever repented of what happened that night in July 2003. Rather, the lengthy passage of time that has followed simply allowed you eventually to become a little older and a little wiser. This happens to almost everyone. It is not an indication of anything unusual or particularly credible. Furthermore, in inviting me to ignore your unchanged lifestyle up to 2017, but give you credit for the way you changed your ways thereafter, Miss Wilding Casey is effectively asking me to give credit for a process that took place over the years whilst you were out of prison and Mr. Malkinson was serving his sentence. You were only able to develop in the way that you did because you sat back and enjoyed your liberty at the expense of another innocent man. In reality, Miss Wilding Casey is asking me to reduce your sentence for something that not only happened because you managed to evade justice for so long and at someone else's expense. I cannot accept this submission. However, I do accept that your altered lifestyle and behaviour are relevant to the assessment of dangerousness, which I turn to next. The prosecution have suggested that the offending in this case was so serious that I should impose a life sentence. If you had been charged shortly after 2003, and I was sentencing you as a 29 or 30-year-old man whose future was still unwritten, I might well have acceded to this suggestion. However, it is here that your altered lifestyle since 2017 really assists you. I cannot say that I consider you will present a significant risk of harm to the public for the whole of the rest of your life. However, assessing exactly what risk you will present and for how long is difficult. You were a cause for concern, primarily because of the incredibly grave circumstances of these offences. However, I'm also troubled by the general behaviour over a long period of time, which involved deliberate, frequent intoxication, an attitude that you were entitled to sex from others. You boasted in interview of never having any trouble getting women to have sex with you, giving the impression that you expected it of them, and periodic episodes of loss of temper and violence generally directed towards women, as with the arson offence, and some other incidents or alleged incidents of domestic abuse directed at your ex-wife. I asked for a pre-sentence report specifically because it was obvious that I would need to assess your dangerousness and that it was likely to be troublesome. It is significant and a matter for concern that the probation service officer who interviewed you and provided the report clearly also finds this difficult. This is because your stance remains that you deny committing the offences. This is, by definition, not a stance I can accept. But it means that, as you appear before me today, you remain apparently without remorse or regret, and you appear to have no readiness to tackle and address the causes, characteristics, and circumstances that led to the offending. I have to consider what, if any, danger you will present to the public when you're released from prison. In all the circumstances, I consider that you will present a significant risk of serious harm, not indefinitely, but for a period of some years. This is a case where an extended sentence is justified and necessary. In assessing its duration, I have in mind your age, and the age you will have reached at the date of your release and at the date of the completion of the custodial sum. So I come now to my sentence. Will you stand, please, Mr. Quinn? Taking the 2 rape counts as the lead offences, I will impose the same sentence for each. The sentence for count 3 and 4 will be as follows. There will be a custodial element of 21 years. I recognise that this is above the normal guideline range, even for a rape in the A1 category, but I consider this unavoidable given the extreme and unusual circumstances of this case. Added to this is an extension period of 3 years on account of dangerousness. This gives a total of 24 years. As already indicated, the sentence on count 1 is 12 years. The sentence on count 2 is 7 years. The sentence on each count is concurrent with the sentences on the other counts. I'll now explain the effects of this sentence. I've imposed a total sentence of 24 years. The time that you've served on remand will count towards this. I've been told that it is agreed that this comes to 633 days. Following your release, the remainder of your sentence will be served on licence in the community. You must comply with all of the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the term in custody. I have to make ancillary orders. I certify that you've been convicted of a sexual offence so that you must, for an indefinite period, keep the police informed at all times of your personal particulars, the address at which you are living, and any alteration in the name that you're using. You will be given full details of these requirements on a form at the end of this hearing. The offence of which you've been convicted is one which will make you subject to barring from working with children or others for an indefinite period. You will be told of the restrictions under the Safeguarding Vulnerable Groups Act 2006 by the Disclosure and Barring Service. Thank you. And that will be all. This sentencing hearing is now at an end. Now, I think that you will probably all agree that Mr. Justice Bright treated the victim, the hero of this story, with the respect, the admiration, and the gratitude that she deserves. And that he treated Mr. Quinn with the dignity that all offenders are entitled to, but made a sensible job of approaching the sentencing exercise. But there's a few things that happened after that hearing that I think are worth just briefly talking about. In particular, we know that Andrew Malkinson was behind bars for 17 years, and he was not particularly happy that he had been given a life sentence and Paul Quinn was not. So he made Mr. Malkinson made a statement which was released through a charity that campaigns against wrongful convictions. And he says, "I got sentenced to life imprisonment and served more than 17 years inside. Throughout that time, I didn't know if I would ever be released. Paul Quinn, who has a track record of violence and sexual offences, and who let me rot whilst he enjoyed his freedom, could now be out after just 14 years, and will certainly be out after 21. I hope this man does not get parole and that he serves longer than me. Anything less is not justice. I am also appalled for the victim, who has suffered so gravely and whose real attacker has today gotten off lightly. My thoughts are with her and her loved ones, who I hope today nevertheless brings some peace to." Mr. Malkinson went on to say later that he was relieved that this chapter of his ordeal was over, but that it wasn't the end. And his solicitor, Toby Wilton, made the following statement. "While Andy is relieved that this chapter of his ordeal is now closed, it isn't the end of this matter as far as he is concerned. Andy's still fighting to persuade the government to overhaul the scheme by which the victims of miscarriages of justice receives nowhere near the compensation they deserve. Currently, the costs incurred in trying to achieve a fair and suitable compensation are deducted from the final amounts that a victim receives. This effectively means that victims of the most serious miscarriages of justice, such as Andy, are expected to pay for the privilege of securing justice. This is clearly not right and unfairly affects only those, like Andy, who have suffered the most." And I think that that is absolutely a fair comment. If the cost of seeking justice, and in other words, the release and seeking the compensation, is more than you receiving compensation, then you're not really being compensated, are you? GMP also made a statement after the hearing, and the statement was made by Detective Chief Superintendent Rebecca McKendrick, who was the SIO, Senior Investigating Officer in the case. And she said this: due to the extraordinary courage and resilience shown by the victim, who has continued to engage with the criminal justice process through 2 trials, the outcome of this case has been possible. The force has apologised to the 2 victims impacted by this ordeal, the survivor of the heinous attack and Mr. Andrew Malkinson. To commit such a violent attack raises concerns that there may be other victims out there. If you believe that you have been a victim or have information you have not shared with us, please know we want to hear from you. We promise that we will support you and we will listen to you. Now, I've put a banner across with what I'm about to say, but she asked that anyone with information related to the case call GMP on 101. Contact them via their website, gmp.police.uk. Quote, Operation Canopy. Or you can anonymously call Independent Charity Crime Stoppers on 0800 555 111. Now, I want to unpack a little bit how the sentence is going to work, because I don't think the judge really covered that part in enough detail, and that's my very only criticism of his entire approach to the exercise of sentence. He was given a fixed 24-year sentence. The prison element of which is 21 years. He would normally be eligible for release on a strict license, i.e. strict conditions of release, at 2/3, which is 14 years. But the judge made a special finding that Quinn is dangerous. So that bit where we talked about dangerousness was important. So when he reaches 14 years, he'll have to ask the parole board to review whether he has been rehabilitated. It will judge whether he is safe to be released. But even if they say that he is not eligible to be released, at 21 years, he will automatically be released because that's the end of the fixed prison term. He'll be in the community, but he won't be free. He will be on license, which place conditions on his movement and his life, and that will last for 3 years. If he breaks any of the conditions, whenever he's released on parole, released on license, he could then be returned to prison for the remainder of the sentence, or for a period somewhere in between. So that's all I wanted to cover for today. I'd be interested to know what your thoughts are about the way the judge dealt with this sentencing process. So I've talked in other episodes about how the sentencing guidelines really provide judges with a framework within which they conduct their sentencing exercises, and it means that there is more consistency across sentences given by different judges, but it still gives them some leeway to consider all of the circumstances of an individual case. And I appreciate that particularly people who aren't from the UK will potentially think that the terms provided in the sentencing guidelines aren't enough, particularly when you look at the way, say, for example, that in the USA, judges can and often do impose very lengthy custodial sentences, often consecutive sentences for different offences, so that they run one after the other. And so you'll hear that someone's been sentenced to 533 years in prison, and clearly they're not going to live that long. But in the UK, we try and run concurrent sentences, generally speaking, and then increase the overall sentence for totality. But what do you think? Do you think the judge was right to refer to this anonymised lady as a hero? I certainly think he was right. I think that anybody who, particularly in relation to domestic abuse, in relation to sexual offences, and that type of thing, who supports a prosecution, knowing that that increases some risks to them, but wanting justice. Apologies. In way of explanation, I'm not actually tired, but I keep yawning because I've perforated my eardrums and it keeps making me feel like they're going to pop, and then it makes me yawn. So I apologise, but such is life. I've got to deal with it. I kept it relatively under control during the period when I was reading it, but they now feel like they're going to burst all over again. What are your thoughts? What do you think about the UK's version of sentencing guidelines? What do you think about how the judge dealt with this particular offender, how he dealt with the offences? And most importantly, I want to know what you thought about how he dealt with references to the hero of the hour. On that note, I'm going to leave you. Next time I'll come back and I'll go through the timeline of the case throughout the years in terms of the legal case, because I think that'll be really interesting. And I know that a lot of you will be left with, well, how did you go from 2003 all the way to 2022? What's happened in that intervening period? And it, to be fair, it's quite a lot. So there's not time to do it now, but next time we'll look at doing that. It just remains for me to say, look after yourselves, look after each other, and I will see you next time.